Hello, Dr. Sushma Singh this side. Today in Unit 22, Globalization, Privatization and Indigenous Knowledge, we are going to start our lecture with the topic World Trade Organization, WTO. As we already mentioned, the volume of the trade increased substantially towards the end of the 20th century, and it was felt that there ought to be regulating body which looks into trade agreements between the countries. After World War II, there was an attempt to set up the International Trade Organization ITO, which never materialized. But in 1947, a body came into existence called the GATT, General Agreement on Tariff and Trade. It did not take long for the General Agreement to give birth to an unofficial de facto international organization, also known informally as GATT. Over the years, GATT evolved through several rounds of negotiations. The last and the largest GATT round was the Uruguay round, which lasted from 1986 to 1994 and led to the WTO's creation. Whereas the GATT has mainly dealt with the trade in goods, the WTO and its agreements now cover trade in services and in traded inventions, creations and designs. The organization describes itself thus: there are a number of ways of looking at WTO. It is an organization for liberalizing trade. It is a forum for government to negotiate trade agreements. It is a place for them to settle trade disputes. It operates a system of trade rules. At its heart are the WTO agreements negotiated and signed by the bulk of the world's trading nations. These documents provide the legal ground rules for international commerce. They are essentially contracts binding governments to keep their trade policies within the agreed limits. Although negotiated and signed by governments, the goal is to help producers of goods and services, exporters and importers conduct their business. Some of the basic principles that WTO involves are trade without discrimination, free trade through lowering trade barriers, general agreements on trade and services, trade-related intellectual property rights, etc. Since this unit deals mainly with the implications of patent regimes on indigenous and traditional knowledge, let us look into the features of TRIPS, which is a major area of WTO regime. Let us examine in the following section each of the areas which come under the TRIPS agreement to further understand what these entails. Now let us move to the next topic, that is trade related intellectual property rights, TRIPS. Ideas and knowledge are now considered as an important part of the trade relations. Patents and copyrights are awarded to people and organizations to protect their creative and innovative outputs into products or processes. Creators can be given the right to prevent others from using their inventions, designs, or other creations and to use that right to negotiate payment in turn for others using them. There are intellectual property rights. They take a number of forms. For example, books, paintings, and films can come under copyright. Inventions can be patented. Brand names and the product logos can be registered as trademarks, and so on. Governments and parliaments have given creators these rights as an incentive to produce ideas that will benefit society as a whole. The extent of protection and the enforcement of these rights varied widely around the world. And as intellectual property became more important in trade, these differences became a source of tension in international economic relations. As we already mentioned, IPRs are meant to protect the creative and innovative efforts of organizations, companies, or people, and they cover a range of products and processes. The following areas are covered under the TRIP agreement: copyright and related rights, trademarks including service marks, geographical indications, industrial designs, patents, and layout designs of integrated circuits. Now let us discuss what is copyright and related rights. Under this category, the rights of the author and artist who have created literary works such as the books and other writing, musical composition, painting, sculpture, computer programs, and films are protected by copyright for a minimum period of 50 years after the death of the author. Also protected through the copyright and related rights are the rights of performers, for example, actors, singers, and musicians, producers of the phonogram, sound recordings, and broadcasting organizations. The TRIPS agreement ensures that the computer programs will be protected as literary works under the Berne Convention and outlines how databases should be protected. It also expands international copyright rules to cover rental rights. Authors of the computer programs and producers of the sound recording must have the right to prohibit the commercial rental of their works to the public. A similar exclusive right applies to films where commercial rental has led to widespread copying, affecting copyright owners' potential earnings from their films. Now let us discuss what is trademarks. The agreement defines that what types of signs must be eligible for protection as trademarks and what the minimum rights conferred on their own owner must be. It says that service marks must be protected in the same way as the trademarks used for goods. Marks that have become well known in a particular country enjoy additional protection. Now let us discuss geographical indications. A place name is sometimes used to identify a product. The geographical indication does not only says where the product was made. More importantly, it identifies the product's special characteristics which are the result of the product's origins. Well-known examples include champagne, scotch, tequila, and Roquefort cheese. Wine and spirit makers are particularly concerned about the use of place names to identify products. And the TRIPS agreement contains special provisions for these products, but the issue is also important for other types of goods. Using the place name when the product was made elsewhere or when it does not have the usual characteristics can mislead consumers and it can lead to unfair competition. The TRIPS agreement says countries have to prevent this misuse of the place names. Now let us move to the point industrial design. Under the TRIPS agreement, industrial design must be protected for at least 10 years. Owners of protected designs must be able to prevent the manufacturer, sale, or importation of article bearing or embodying a design which is a copy of the protected design. Now let us discuss what is patents. The agreement says patent protection for inventions must be available for at least 20 years. Patent protection is available for both products and processes. Government can refuse to issue a patent for an invention if its commercial exploitation is prohibited for reasons of public order or morality. They can also exclude diagnostic, therapeutic, and the surgical methods, plants and animals, and biological processes for the production of plants and animals. Plants varieties, however, must be protectable by patents or by a special system, such as the breeder's right provided in the Convention of UPOV. The International Union for the Protection of New Varieties of Plants. If a patent is issued for a production process, then the right must extend to the product directly obtained from the process. Under certain conditions, alleged infringers may be ordered by a court to prove that they have not used the patented process. In the recent Doha meetings of WTO, it was agreed that the TRIPS agreements does not and should not prevent members from taking measures to protect public health. They underscore each country's ability to use the flexibilities that are built into the TRIPS agreements. They also agreed to extend the exemptions on pharmaceutical patent protection for least developed countries until 2016. On one remaining question, they assigned further work to the TRIPS Council to sort out how to provide extra flexibility so that countries unable to produce pharmaceuticals domestically can import patented drugs made under compulsory licensing. A waiver providing these flexibility was agreed to on 30th August 2003. Now let us move to the next topic, integrated circuit design. This particular item and area was adopted in 1989, but it is yet to come into force. The protection for this is available for 10 years. Now the next is undisclosed information, including trade secrets. Trade secrets and other types of undisclosed information which have commercial value must be protected against breach of confidence and other acts contrary to the honest commercial practices. But reasonable steps must have been taken to keep the information secret. Test data submitted to governments in order to obtain marketing approval for new pharmaceutical or agricultural chemicals must also be protected against unfair commercial use. On the face of this, it seems perfectly valid that there should be uniform laws that can be applied equally for all trading partners. But the TRIPS agreement has come in for severe criticism from developing and least developed countries. They feel that the gradual erosion of the developed countries' supremacy in the manufacturing and technology due to the rise of the Asian countries as competitors has prompted industries and companies from the north to become pressure groups which have been working behind the agreements. The industrial lobbies convinced developed countries' governments on the need to link trade with IPRs in order to prevent imitation and to increase returns on the research and development. Monopoly rights granted by IPRs were regarded as crucial to prevent the developing countries from further undergoing the catch-up process towards the industrialization based on the imitating and copying technologies as the developed countries themselves had done. In other words, IPR protection was a tool to guarantee and comparative advantage that had so far ensured the developed countries' technological supremacy. Here we want to close this lecture. Thanks for so patientful hearing.